I'm looking at a survey from our friends at Employers Resource Association. At the end of the video, I'll say where you can get this online, or happy to send it to you. It's called How Have Companies Responded to the #MeToo movement? And asked a number of questions. I think it's interesting. 98% of companies have a policy in place. 90% of companies have a structure in place for reporting. I think we'd expect that. Those are good things. But what's significant to me about this is that I think it conveys that not a lot of companies have really made changes in light of this movement. I want to challenge you a little bit on that. So, for example, most feel confident about their department's ability to handle claims of harassment. Only 7% felt an update to their policy was needed. Only 20% felt a need to recommunicate their reporting structure. And I'm not saying those particular things need to happen in all companies, but I do think this is consistent with a sense that I get that companies and their law firms are not necessarily changing a lot in light of what has been really a remarkable period of time as far as the reporting and the public awareness. And I just want to challenge us employers a little bit on that. So, because a lot of things, some things are definitely changing, and some things I think will change. So, things that are changing in a lot of states and some localities, we're seeing legislative activity. A lot of it's addressed towards arbitration clauses in employment agreements. Some of it's addressed toward confidentiality and settlements to resolve harassment-related claims. I don't happen to think those are the things that are really going to change behavior, but those are happening. They'll affect employers. I think it's reasonable to think that juries will be harder on employers in harassment cases. I think it's reasonable to expect that judges may interpret things that have gray areas, such as the term severe and pervasive. Harassment is not illegal unless it's severe and pervasive under federal law. There's a lot of room for interpretation there. And over the years, there have been cases that I think we would read as employers and people who represent employers and think, boy, that's some bad behavior. But a court has said that's not severe and pervasive. I think that balance may shift somewhat. And certainly, I also think it's reasonable to expect that judges and jurors will expect employers to do more in terms of their efforts to prevent harassment. A policy and training and responding well to complaints, that's been the standard for quite a while now. I'm not sure that's going to be enough, particularly as it relates to identifying unreported harassment, which, as I've mentioned in other videos, is very common. So I am challenging employers that I work with to do a couple of things. One is to look hard at your training. These videos, of course, are maybe part of that, looking at something more frequent, and even if they're shorter interactions, maybe a little bit more topical and something you can discuss and have harassment prevention be top of mind on a continuous basis, not just on the times of the periodic training, whether it's video or in person. The other thing I think employers should challenge themselves on is how can we identify unreported harassment? I've mentioned in another video just understanding the difficulty in reporting, but I submit that employers can think about other ways than the traditional give us a report, all the names that we can act on. You've got to be a little more subtle than that, maybe use technology in certain ways, act more aggressively on subtler reports and pieces of information. So I do personally think that what is expected of employers is going to change on several of those levels, and that we're going to need to be responding in that. I'm not sure we figured out exactly how yet. So if you want to look at this chart, it is at www.hrexperts.org. HR Experts is HRXPERTS. And yes, I left the first E out of experts.